Not long ago, we recorded an episode on the controversy between Scarlett Johansson and OpenAI, where we looked at the legal theories Johansson might use if she ever decided to sue over the Sky voice. At that time, we were essentially guessing what a lawsuit would look like because, well, it hadn't happened yet. We talked about the right of publicity and the Midler and the Waits cases as the roadmap for a potential claim by Johansson against OpenAI. But today, we don't have to guess anymore. We actually have a case. David Greene, the longtime host of NPR's Morning Edition and current host of KCRW's Left, Right, and Center, has filed a lawsuit in California against Google and Alphabet. He's alleging that Google's breakout AI tool, NotebookLM, didn't just accidentally sound like him. He claims they used his voice to train it. I'm Scott Hervey, a partner at the law firm of Weintraub Tobin, and today I'm joined by my partner, Richard Buckley. Today we are going to talk about David Greene's lawsuit against Google over its NotebookLM voice on today's installment of The Briefing. Richard, welcome back to The Briefing.
Thank you, Scott. Great to be here.
I'm going to point out something for our listeners and our viewers. So today is St. Patrick's Day. The plaintiff in this case is David Greene, and Richard is wearing a green tie.
All by coincidence.
Oh, and I am not wearing anything green. All right. So let's get into this. So this case involves NotebookLM's audio overviews. And that's a feature that turns documents into conversational podcasts. It's a pretty cool feature. Many users were stunned by how human the host sounded, and they do. But for David Greene, that human sound was a little too personal. So let's talk about his allegations, shall we, Richard?
Sure. Mr. Greene is claiming that the male voice in the AI duo, often called Charlie by the community, is a direct imitation of his distinctive broadcasting persona. He says it's not just a similar tone, it's his specific cadence, his rhythm, and even certain verbal tics that he's developed over decades at NPR.
Right, those are his allegations. And he isn't just relying on his own ears. The complaint, which he filed, actually mentions that he was alerted to this voice by friends and colleagues, asking if he had licensed his voice to Google. To back it up, he hired a forensic voice recognition firm. So let's talk a little bit about that report, shall we?
Sure. The firm's analysis showed a what they call a confidence rating of 53% to 60% that Greene's voice was used to train the model. So in the world of voice forensics, a score over 50% is considered a strong indicator of a match.
Google, of course, has called these claims baseless, saying that they used a paid professional actor. But let's look at the legal hurdles that Greene is going to have to get over in this lawsuit. So Greene is suing for statutory and common law right of publicity, unfair competition, and unjust enrichment.
Starting with the California statutory right of publicity, that's Civil Code Section 3344, Greene must establish that Google knowingly used his voice for a commercial purpose without his consent.
Right. That knowingly element is going to be the battleground or one of the key battlegrounds. Google will likely argue that their LLM was trained on a massive data set or on a specific actor that's not Greene. And any resemblance is purely incidental or archetypal.
Exactly. Under the common law claim, Greene also has to show that Google appropriated his identity to their commercial advantage. This brings us back to those cases we mentioned in the Johansson episode, Midler versus Ford Motor Company, Waits versus Frito-Lay. Both cases involve the use of a sound-alike singer singing a song in the style of the artist in a TV commercial. Both plaintiffs sued for violation of rights of publicity under the Civil Code and under common law. The trial court in Midler initially granted Ford its motion for summary judgment, but on appeal, the Ninth Circuit, addressing Midler's common law claim, held that when a distinctive voice of a professional singer is widely known and is deliberately imitated in order to sell a product, the sellers have appropriated what is not theirs and committed a tort in California. The Waits Court, which relied on Midler, found similarly.
Right. Yeah. The Midler and the Waits cases held that when a voice is a sufficient indica of a celebrity's identity, the right of publicity protects against its imitation for commercial purposes without that celebrity's consent. So in those cases, the court found that when a voice is distinctive and is widely known and is deliberately imitated to sell a product or a service, that's a violation. So Greene's going to have to establish that his voice is, in fact, distinctive and that his voice is widely known. I mean, Greene does argue that his voice is his identity. He says it's what has built his entire career, but I don't know that, those are just his allegations. He's going to have to establish this for the court.
True. And the big question for the court will be whether a synthetic composite voice, even if it sounds like him, counts as identity theft if it wasn't a direct one-to-one recording. Greene is arguing that AI ingested his life's work as raw material.
Right. But I mean, still, we're the and we'll talk about that ingestion claim because I think that has given rise to something else. But going back to the right of publicity, if you think of Bette Midler and Tom Waits, like their voices are pretty distinctive, right? It's along the lines of, um, Arnold Schwarzenegger, right? Or James Earl Jones, or what's another? Give me another actor who's got a distinctive voice.
Morgan Freeman.
Morgan Freeman, right? As we just discussed earlier. Exactly, right? I don't know that Greene's voice measures up to that that level.
Yeah, Scott, it's going to be a long road through discovery, especially as Greene tries to get a look at what was actually in Google's training data.
Right. But even before we get into discovery, Greene is going to face a challenge fighting a motion, Google's motion to remove the case to federal court on the grounds that Greene's claims are preempted by the Copyright Act.
Scott, that's really interesting. Could you talk a little bit about Google's motion to remove?
Yeah. In their notice of removal, Google alleged that the suit belongs in federal court because Greene's claims arise under the Copyright Act. The Google alleges that all four causes of action concern the unauthorized use, copying, duplication, reproduction, performance, display, and distribution of recordings of Greene's voice. Google says that because these claims involve violation of essentially the rights that are possessed by an owner of a copyright, his claim is really dressed up as a copyright claim with other attendant claims, and it belongs adjudicated in federal court. I think the problem there is going to be Greene's not necessarily the owner of the audio recordings. It's most likely NPR that owns the copyright in these audio recordings, and NPR is they're not a party to this case.
Right? They'd be an indispensable party within the copyright framework, and they're not there. These are state law claims brought by an individual based upon statutory rights.
Right. I mean, we'll see where Google's attempt to remove the case to federal court goes. They do say Mr. Greene's claims are preempted by the Copyright Act. thereby vesting this court with subject matter jurisdiction. Uh, so we'll see what the court does with this. It's interesting because if the court does in fact find that all of Greene's claims are essentially um, a kind of recontextualized copyright claim with other attendant claims, I don't know. I don't know if he's going to be able to sue, or at least I don't know that he's going to be able to sue. Um, I don't know if he's going to be able to sue based on the ingestion of his voice. He probably still will be able to sue based on the output of the LLM, which constitutes or could constitute a violation of his right of publicity. But he may not be able to sue over the ingestion of his voice as training data for the LLM.
Right, which is probably not what he's suing for in the first place. It just kind of rings like a straw man argument to me, where the defense sees a defense in the copyright law to this product of training, and they are trying to repackage it for their own benefit as a copyright case.
Yeah, no, I hear you, and it makes sense um, because there's been cases that have found that training on data that is rightfully accessed uh, constitutes fair use. So I can see why they'd want to recontextualize his case in this manner. But I don't know that they're going to be able to recontextualize the part of the case that deals with the output, which is really, as you noted, is the heart of the case, and it's what Greene is suing over. I think this is also just probably a way to get him to burn some money, right? I mean, this is what happens when you go up against Google. You're going to face a slow draining of your pocketbook as you try to push your claims forward. But they're entitled to raise their defenses as they believe them to be meritorious. So we'll see what the court does with this, and we'll see where this goes forward. I think Greene's going to have a quite an uphill battle establishing that his voice is like widely known and recognizable. But we'll see. We'll see what happens. Well, thanks again, Richard, for joining me today. Always great to have your insights. And thank you, our listeners, for joining us today on the briefing. If you found this episode helpful or interesting, please take a moment to subscribe, like, and share it with your network. We'd also like to hear from you, so leave us a comment or review and let us know what topics you'd like us to cover in future episodes. I'm Scott Hervey. I'll see you next time on the briefing.